Hi real estate professionals, welcome to Velocity Title's Title Minute. Today our expert real estate attorney Glenn Donaldson will be discussing adverse possession. Don't let somebody lawfully take your property. At the end we'll share our contact information and we'd love to hear from you, so send in any questions or comments you might have and we'll get back to you as soon as we can. And now, here's Glenn.
Thank you, Lauren, and welcome back everybody to the Title Minute by Velocity National Title Company. I'm Glenn Russell Donaldson, your real estate attorney. And today we're going to turn to a subject that's actually near and dear to my heart. I've handled a number of cases over my career relating to a little used and little known law called adverse possession. And believe it or not, it is true, somebody can take title to a property simply by using that property openly and notoriously for a period of 20 years. In Maryland, the statute of limitations on that is 20-year statute, so they're required to use the property. So let me give you an example. What frequently happened in larger tracts of land historically is families owned the tracts. Mom and dad wanted to parcel off some of the land and give it to their sons and daughters. And in doing so, they would subdivide the property, but many times one of the brothers or sisters would use the other brothers or sisters' property for ingress, for egress, for plantings, or whatever else they agreed to do. Over time, however, the brothers and sisters would sell off their interest in some of the parcels of property that mom and dad subdivided. In that scenario, every once in a while, you would have a situation where one of the parties would continue to use the property of their brother or sister who had transferred the property. And if they did so for a period that included some period of time that maybe the brother or sister owned the property and now the new owners have owned the property, whatever that example may be, for a 20-year period or more, and they use that property under this standard, this legal standard called hostile, open, and notoriously, they are in fact entitled to file a lawsuit in the circuit court of the county where the property is and claim that property for themselves. It's called adverse possession. So many times that these situations have come up, the real estate professionals have come into my office and said, oh gosh, we have this situation where the neighbor was a prior family member, they've been using the property for so many years, and they're continuing to use it. How do I protect my clients from that neighbor filing a claim for adverse possession? And it's a very simple way to do it. Number one, you can eject the person. You simply object and eject them from use and former use of the property. Number two, you have that person release or sign away any claim or right in adverse possession before your clients go to settlement. You don't want to handle this after the fact and create a situation where you've upset the neighbor who's been using the property and they simply file the claim in the circuit court, and they would in fact be entitled to relief under those set of facts. That relief would look like an order from a circuit court granting a portion of your property or your client's property over to that neighbor who had been using that property openly and notoriously for a period of 20 years or more. It happens, and you don't want to get your clients caught up in that trap. It's called adverse possession. Remember, for that and any other type of legal questions relating to real estate, you can contact us at contractquestions@velocitytitle.com, or please feel free to reach out to us on our contract hotline, and that is 1-800-MY-RE-LAW. That's 1-800-MY-RE-LAW or 1-800-697-3529. Once again, I'm Glenn Russell Donaldson, your real estate attorney. We'll talk soon.